Welcome to Stream Detroit, the show for cool people doing cool shit. I'm Mike McClintock, your host, with Brad Fox, Sean Yalda, and Jeff Wagner today. We're doing another demo day. Normally we do a demo day, somebody has an app or something like that, but today we're with Teymour El-Tahry of Vortex IP, and he's an intellectual property lawyer. So everything that Teymour does is in his head. So we're going to demo Teymour's head today and talk about intellectual property law and how that applies to startups. First, welcome to the show. Thanks for coming on.
Yeah, thanks for having me, Brad, Mike. Thank you very much.
Mm-hmm. So what exactly does an intellectual property lawyer do?
Well, traditionally, there's different types of IP attorneys. There is patent attorneys, which is the vast majority of IP attorneys, and patent attorneys will either work in prosecution, which is the drafting and procurement of patents. And then there's patent litigators who will litigate the patents. And then there's trademark attorneys who counsel clients on getting trademarks. And then there's also, you don't see very many of them, but people who specialize in copyright as well. So.
Okay. What's the difference between patent and copyright?
So copyrights protect artistic works or creative works, and patents protect technical innovations. So both come from the Constitution, where the founding fathers thought that a good economy is going to be based on a system where we reward creative types, both technical creative types and also artistic creative types. So traditionally, copyrights were thought to protect works such as books, poetry, drawing, sculpture, and songs, and albums and photographs. But has been also applied to other types of creative works, including the code which you write, as well as graphical user interfaces. But it's kind of within that realm. It's the look and feel of your GUI. So that's copyright. Patents, they protect inventions. So if anything from mechanical inventions to chemical, biomedical, there's
people patenting genes, aren't they?
Well, it depends.
Blue jeans or jeans with a G?
Maybe both.
Yeah. Well, yeah.
Blue jeans are probably more copyright.
Well, actually, probably blue jeans. If you've got a new way of making blue jeans, would be easier to patent than jeans these days. Jeans and software are kind of in the are kind of hot button issues within the patent realm these days.
It's kind of a big fight between people who believe that software is easily patentable or should be patentable, and then there's a whole group of software people who believe that software should never be patented.
Like the open coders, right? Like that kind of a thing?
Absolutely. And one thing that I do is I work with startups now that a lot of them are open coders.
Like Linux people, like in kind of old school to a certain degree, right?
Absolutely. And I think one of the things that people have a problem with is not necessarily the fact that people are patenting software. It's that these software patents are extremely broad, extremely vague and ambiguous, not enabling, and generally low quality, and they're being bought up by non-practicing entities, which people commonly refer to as patent trolls, and you'll find them enforcing these against companies. But I think a lot of it is kind of a PR campaign against software patents. The way I like to look at it is, if you're a company that's pouring lots of resources into solving technical problems and researching and doing various things in order to make your company better, you should have some sort of mechanism by which you can protect yourself in order to bring your product to market. I mean, as somebody who got into law because they wanted to actually one day start their own startup, one of the biggest impediments that I think a lot of people face is, well, I'm just going to create this, and all of a sudden, one of the big players is going to come and copy everything that I do, and then I really don't have anything to stand on. They have resources, they have money, they have marketing, they have brand name, they have everything. And unless I really come and just blow it out of the water and with speed and gusto, I'm just basically disclosing what my ideas are so that a bigger fish can come in and eat up my idea. So with respect to software patents, I think if when I'm counseling clients, the goal that we try to have is well thought out patents, well drafted patents that really get to what the invention is, and that has claim scope that is well defined. And for your readers or for your listeners and viewers out there, we can get into what a well defined claim or well defined patent is. The idea that I think what a lot of people that are anti-software patent think, and maybe part of what they're saying is true, is that these people who got these patents 10, 15 years ago never had had no idea what these claims were going to be, what kind of litigation they were going to be getting into down the road. And so, and you look at the patent and you say, wow, this patent is directed towards, unlocking a car with a key lock, and now you're trying to read it upon like a Bluetooth radio module because of this wishy-washy language that you're using, and so maybe the software, the anti-software camp, has a point in that regard, but generally, used correctly and with a well-developed strategy. It's there to help protect the little guy, really. And the reason that it's not is right now is because the process is very expensive and for a lot of small companies almost cost prohibitive, which is unfortunate because a lot of the innovation and the technical problems that you're facing as a startup come in your first few years, where you're saying, well, how the hell are we going to do this? It's great. We have this great concept, but it seems like it would be impossible to do X, Y, and Z. Mm-hmm. And then you spend a lot of time trying to figure it out, and that's resources. As the old adage says, time is money. And maybe you hire some people so that money is money. So it's a very good way to help turn those, what people have traditionally thought as sunken research costs, into a tangible asset down the road. And from a startup's perspective, once you have some patents on file or you have like an IP strategy, not every startup sets itself up for a patent, and I think that's kind of part of the strategy is figuring out, well, do we have anything that we should be patenting, and if so, what is it, and how do we best disclose this?
So you're a broke startup, or you're a mostly broke startup. How do you even begin to try to deal with the intellectual property world? Because you just think, oh my gosh, how are we gonna be able to afford something like that? Where do we even start? Can we even afford to walk in the front door of some of these law firms? That kind of stuff. Where do you come into that mix?
Yeah, and so where I come into that mix is previously I'd spent a lot of time working at different law firms, both of IP boutiques, mm-hmm. law firms that specialize in intellectual property, and general practice firms with strong IP departments. Mm-hmm. And one thing you would see is that you do get a lot of startups coming to you, and they don't really know what it is that they want. Mm-hmm. So they'll come and they'll say, well, here's a lot of our design documents, or here's some screenshots of our app or of our website or anything, And unless there's something particularly innovative about that, that may not be the best strategy going forward. And they kind of want to see basically like a book that outlines their entire software, even if it's, hey, we have something very, very simple that's well known, and they kind of expect to see that in there because it's part of what their software does. Really, where I come in is, I work with, first of all, I'll work with inventors to kind of help them think about what is an invention. What is it that we're going to seek to patent?
And you're functioning as the attorney. Are you doing a patent at that point?
Yeah,
copyright.
This was at in my old firms, and what I do now. You kind of help them think of, what are we doing that's different than everybody else? What's the whiz bang, as one of my mentors.
How long does that take?
It really depends on the invention. I mean, it usually takes. It depends on how well you know the technology. Right now, I work with a company that's doing some very cool things out of California, and now I understand their technology very well. So initially, we'll have a very quick talk about, or they'll get disclosed to me, through writing. Can
we patent this podcast?
No, we can copyright it though.
Okay.
In fact, just by putting it out there,
copyright
it's copyrighted.
2014.
Exactly.
That's awesome. Well, I'm sure you see a lot of crazy ideas along those lines, right? So you probably see people who come into you and say, I've got this great idea. And, whether it's a technology based or otherwise. And at some point, you probably know either in your gut or, through your experience that this is not a great idea. And there's the egos at stake, right? So let's say a person, fresh out of college has been thinking about this app or this software solution. What does that conversation look like? I'm sure there's, some heartbreak, right? And it's like, well, this isn't patentable or this isn't copyrightable. Have you kind of encountered that kind of a situation in your experience? Yeah,
there's a couple of different situations that you'll run into. There's, somebody has invented something that's just not new, or they've invented something, in air quotes, for the listeners out there.
Luggage with wheels.
Exactly. That's exactly right. And in those cases, you do a knockout search. So I'll just go on, a search engine such as Google.
Google Patents or something like that.
Google
right?
Patents, or if their instruction is not to search patents, I'll try to do market research and find what's kind of been sold already, just to kind of say, hey, look, you have X, you have Y. An examiner is going to look at this. We got to disclose this to the patent office. You're not going to get it. The other thing that you'll get is just kind of ideas that are physically impossible. So the classic example that I think every patent attorney who's practiced long enough is the perpetual motion machine.
I was just going to say that.
And you come and they'll come to you and they'll be like, I have this machine and it doesn't require any energy to make it work, and you can create energy with it. And you're like, well, it kind of sounds like a perpetual motion machine. And they're like, no. This is
really a better mousetrap.
I have one of those.
Yeah, really. Yeah, exactly. And those, you'll tell them, well, and the patent office does reserve the right to call shenanigans, as I like to call it.
Right.
I don't think that's the official term, but they can ask for to show proof of concept that this does in fact work, and ask for a prototype. And they'll do so when people claim that they've invented a perpetual motion machine. I imagine time machine as well.
Has anybody patented a time machine?
I'm sure.
I think Da Vinci would have something like that.
Yeah,
by
I think
now.
they call it a clock.
Oh, is that right?
Yeah, sorry about that.
Well, you can go forward. You just can't come back.
No, exactly.
Okay.
But yeah, no, I imagine. So the patent office started publishing patent applications in 2001. So before then, you wouldn't be able to see what people have tried to patent until it actually issued. So if somebody tried to patent a time machine, as long as they submitted it after 2001, then it would be on the public record. So I can certainly find out. In fact, after this podcast ends, I will probably get vortexed into finding a
time machine?
A
patented time machine.
Somebody trying to patent a time machine.
That's a great idea.
I don't think
we said it first, right? So it's ours. We own it.
You've
We're
got all claims to the time machine.
Yeah. So you working in the startup space, as Mike kind of hinted at, sometimes they're just bootstrapped. So it could be a couple of people right out of college who have this great idea, may not have a lot of cash. They might have friends and family who help kind of them bootstrap, where they might have a savings account. So from your perspective, that's, hiring a patent attorney or an intellectual property attorney like yourself. They probably think, hey man, the meter's going to be running. I mean, is that something that you encounter, and how do you, assuage their fears, if you will, that, hey, look, it's not going to be as expensive as you think, with a meter running with an intellectual attorney such as yourself?
So I think one thing is another thing that I kind of do is, once I left the law firms, I work out on my own with a couple of other guys. We're loosely affiliated, and we have a much slower billing rate because we don't have the overhead that a law firm does. Law firms are great for a lot of different things, but one of the things one of the drawbacks is, if you're working at an IP boutique, you're servicing 10, 15 clients, 5 big ones, 3 big ones. So you don't have a lot of time to learn, a one and done patent application for a small startup. So that's kind of why those costs, like that first patent is usually the most expensive, because the person doesn't know, there's no in-house IP counsel that's going to know how to get you the information efficiently. The person doesn't know what a patent is, so there's a lot of teaching and hand-holding that goes on. So that's, one thing, you can find somebody like me that works on kind of what I do is I'll do a lot of the drafting, the kind of figuring out what's patentable at a much lower rate, and then we'll work with a law firm to file and to handle the parts that they're very good at. And then once their budgets grow, and once they can afford to go to the law firm, then you've kind of put the procedures in place to disclose the invention. Here's the part of our system that we think there's a new part, and so we'll put our resources, if you will, into explaining this and putting in algorithms, putting in different expanding the description of it, putting figures in there. That's how you can guarantee you're getting the best bang for your buck. There's no magic bullet to say, hey, I want to pay $100 for a patent, and there's always going to be costs associated with it. But if you work with a smaller firm, I think that's a very good way to go. Find a firm that is a smaller firm that has maybe 3 or 4 people that broke off from a larger firm. They'll usually have reduced rates, and they'll have areas of expertise. Mm-hmm. So they may be car guys, and if you're doing something that's dealing with the automotive industry, then you go to a firm like that. They may be electrical guys, and you go to those guys. There may be 3 or 4 guys in there. Don't just go to somebody because, hey, he's a patent attorney,
right?
Has a PhD in biochemistry, and I want him to write electrical patents for me. So you want to just make sure that there's a right fit from a technology perspective. If that's the person that's going to be drafting patent applications for you, and go in there with a plan. Really narrow down, like, hey, this is what separates us. We're a company that is, I don't want to get into anything that I've worked on before, so I'll just make an example up.
How about a practical time machine using dynamic, efficient, virtual, and real robots? The crack research team of Sean Yelda and company of Stream Detroit has, in fact, found a time machine patent application. What do you think of that one?
That one looks pretty awesome to me, actually. If the crack research team could just hit that view PDF button, so we could maybe to the right, so we can maybe see some of these awesome figures that I'm sure are accompanying this time machine.
Yeah.
What attracted me or my eyes was build super powerful lasers.
Right.
In air quotes.
Right. I saw that there was a lot of things about DNA in there too. Maybe that one's a little bit impractical.
Yeah. So, but if I was counseling this, when I'm sure Mr. Quoke, what I would tell him
Those are
is
great stick figures.
Yeah.
Scroll down.
Scroll down a little bit. Keep going down.
We got robots.
We've got 38 different figures, by the way. So we've got. He makes a copy of the people. It looks like.
So it's a replicant of some sort. It's a replicator.
Character.
Yeah.
I love it. Well, this is old technology. It's 2009, so I'm sure they've figured this out by now.
It's all Bluetooth now.
So he's actually got some pretty good figures in there,
Right.
though. So, but anyways, if I was, counseling somebody who's made a, dynamic time machine using high density lasers, I would probably tell them, they were to walk into my office, or let's say we were to be chatting at a coffee shop. I would kind of give them 4 major points. Number one, have your shit together. Know what your goal is. Is what makes us different than all other time machines? Is it the high density lasers? Is it the robots? Is it the ability to copy a person and put them in there? And if that's the case, let's say it's the high powered lasers and the robot copies.
Right.
Have a document ready that explains, okay, this is if I was teaching, a fellow time travel expert how to do this, or if I were to take on an understudy that just finished his, bachelor's degree in time travel, what would I do to tell him to say, hey, this is how we're going to build this machine. This is the type of lasers we're going to use. This is the frequency that these lasers are going to operate
Know your
at.
product ABCs.
Exactly. So that's knowing your product ABCs. Like, you have to know how to build it, how to make it, how to build that software. And so it's also...
How expensive is it?
It really depends from invention to invention, but if you do take care of your ABCs and you have your stuff together,
So if you know your ABCs and you have your shit together,
You're gonna
it's
see
probably
it-
not as expensive as you think.
you're going to see dramatic reductions in cost, because otherwise you're asking a patent attorney who has never worked in time travel before to kind of figure out what
Should
those
I-
ABCs are.
Should I have my shit together and know my product ABCs and come in with enough money and not be worried about that it's going to be too expensive, but then take my virtual time machine using DNA with lasers to a mechanical engineering IP lawyer? Should I do that, or should I find a time machine guy?
You'd preferably like to find somebody that's worked in time machines, but
Is that in the yellow pages? I mean, how do you,
well, typically you can look on like the firm's website and they'll say what their expertise is.
time machines?
Time machines, time travel,
Vortex generators, things like that.
exactly. Standard stuff. And so, but you're never going to find it's very difficult to find a complete fit. Like, you're never going to find somebody who studied high density.
Right, there's
lasers
probably not a
for-
really big market for time machines.
Exactly. So you'd want to maybe
Apparently,
say
though, there's some.
exactly. So you try to maybe find a electrical engineer if it's the lasers part of it. If it's a mechanic, if it's the flux capacitor, if that's a mechanical device.
Right.
Then you'd want to.
Have you reviewed the flux capacitor?
I did, and I have a patent on it, so hands off.
Okay.
All right. Well, to be clear, that Back to the Future 1 would be considered prior art. So
I renamed it the Fox capacitor, so that's my last name. So it's like the ABCs. Get your shit together, have your shit aligned, know your product. It sounds like having an attorney like yourself is probably not as expensive as a startup might think, even if they're bootstrapped.
yeah, exactly. And if you go, if a lot of people just kind of open up and say, well, what's the best, most well-known firm that I can go to? Well, one problem with the best, most well-known firm is, as a startup who's coming in for one patent application, they don't really see you as like as a very good client. They have clients that spend millions of dollars with them every day. And then the other thing is their billing rates cater to those types of clients. So you're looking at a $400 an hour guy who just got out of law school that has maybe drafted 1 or 2 patent applications. So it's all about finding the right fit. I mean, if you can afford that, then by all means, test one of those guys out. But there's plenty of guys that are extremely experienced, that are well versed in certain technical areas, that have broken off, that want a little bit more of a lifestyle, and that have smaller shops across the country. You find those guys, ask them to see, a couple of their patents that they've drafted in the past. If you can read it and it makes sense to you. You trust, you talk a little tech with them, you kind of have a trust that they'll understand your technology, then that's probably the right, and ask them, like, how many hours do you think this will take? And I like to hammer home the fact that there is a couple of other hidden costs that people don't necessarily know about. There's a prosecution phase that comes about 2 years down the road, where you actually start going back and forth with the patent office to figure out what the scope of your claims are. So what are the words that we're going to use to define your invention? And then there's issue fees and maintenance fees that come at various points throughout the life of the patent. So those are also some things that can come up that may be a little bit, but presumably by year 2 or 4 or 5, 9 or whatever, you should know whether your company is viable or not. And another mechanism that startups can use is there's something called a provisional patent application. And a provisional patent application is not necessarily an application that's going to be examined, but it's more of like a placeholder, a timestamp.
So like just a disclosure to protect yourself.
You disclose it, you put in a couple of claims. You can have it drafted as a regular patent application, or it can just be a disclosure of, hey, here's our algorithms here.
How much does that cost?
Well,
it sounds less expensive.
That all depends. If you're doing what we refer to as a full-blown provisional, which is basically a utility application, you still haven't figured out maybe all the final implementation details, so you're still fine-tuning it. The drafting costs are going to be about the same, but the filing fees, you're not paying the filing fees. But when you convert it a year later, then you're going to be paying those filing fees. But if you're just kind of saying like, hey, here's my design docs, and like here's pages 4 through 8 are the interesting part. Then it can be much cheaper, and then you have the freedom to go talk to potential investors. Then you can go raise capital and say, hey,
so it's an initial place to protect yourself a little bit.
Exactly, and you've disclosed your idea, you've given enabling disclosure in that sense, and now you can talk to people without fear of them stealing your idea, because you have this patent pending looming large, and so you can and as a potential investor comes to you, they see that you've taken the initiative, that hey, there may be at least something there that they're seeking patents on. So it makes you look better. It can help your valuations. It can help. It can allow you to talk to other companies, partnerships. I mean, there's a lot of patents offer a sword, to use down the road, but there's a lot of different ways you can use them that aren't necessarily litigation based. I mean, you can use them to help foster partnerships. You can use them to help raise money. You can use them for a lot of different reasons. And if all else fails, you have an asset. So you've spent a lot of resources developing something. Now, let's say
at least you got something you can sell.
You have something that you can sell. I mean, Friendster is a great example. Actually, Research in Motion was the most famous patent troll, which I don't. It was really just
the BlackBerry people.
The NTP, the company that sued them. It was actually, the guy was actually a really prolific inventor, and his company just didn't make it, and so he had his patents and he made money off of them.
But then you have like SCO versus Linux.
Yeah. I mean, and you do have people that come in and try to take advantage of the system, but I mean, at the same time, like they do help a lot of.
So you got to take the patent trolls with the good.
Yeah, I mean, there's trolls and there's trolls.
Yeah, trolls.
There's some.
How
people
did we come up with troll?
It was actually.
Is that a legal term? I mean,
it was actually the director.
Is it like Latin or something? I don't know.
It was the director of, or it was the the chief IP counsel of Intel, I believe. They were being sued by a company that didn't make it, so they didn't have a product to sell. And
So let's
the guy
take it to
that took
court and make some
control.
money that way, right?
and he said, these guys are just trolls. They're just trying to kind of stand at places where, they're trying to come up and exact their toll.
When was this?
This was, I believe, in the 90s.
So that's the etymology of patent troll.
That was where the term initially came from. And the irony of it is he actually left, I believe he actually left Intel, and he's at Intellectual Ventures, which is kind of what people.
They're the Paw Patrol.
Yeah, the biggest troll. Not saying they're a troll.
Not that there's anything wrong with it.
Not saying that there's a troll.
them.
Please don't pat me
they're
on
not
this
trolls.
thing saying trolls. But they're a large non-practicing entity. So that's the irony of it. I mean, he leaves.
Is that the nice way to say it? Non-practicing entity?
Non-practicing entity.
Okay.
So he left. He left Intel and then went and joined Intellectual Ventures. So the guy who claimed the term
Became the biggest troll.
non-practicing entity.
Non-practicing entity. They're not trolls. So what's one piece of advice? You get one piece to give to startup founders regarding their intellectual property. What's one piece? The nugget.
The one nugget I would say is do your diligence and have a plan, a strategy and a plan, because if you don't follow those 4 things we discussed earlier, you're going to be, the drunk guy walking into the casino, or the hen walking into the fox farm or something like that. You're just going to
The hen walking
eaten
into the
alive.
fox farm.
that's copyright, trademark.
Yeah,
But that's you're going to.
That'll be in the show notes.
Yes, you're basically walking into a situation where you're going to spend a lot of money, and those costs that I was talking about later on down the road with prosecution, they're going to become much more prevalent because you've got just a bunch of junk, and the whole process is going to become bloated. So, follow those things, have a plan, have a strategy, and you'll come out all right.
All right.
And be inventive. Don't come to us with stupid shit.
No stupid shit. Teymour El-Tahry, thanks
Hashtag
for,
no stupid shit.
Thanks for coming on Stream Detroit and walking into the, what was it, the Fox House?
The hen into the fox
walking
house.
The fox house.
The hen walking into the Fox
Fox
House.
Farm.
Not my
Fox
house.
Farm?
Not my
Fox
house.
Farm.
Yeah, so we can't even.
Oh, different fox.
Yeah, different fox. Completely different one.
All right, it's time to drink.